So just to start out, great big thank you to Gwen and the other volunteers for the Portage Community Rights Group for pulling this thing off. There's a lot of moving parts for these things, so a round of applause for them. So I think I need to open up tonight by apologizing for being a white guy. so we'll do that. I'm a big white guy, tall white guy. So last night in Medina County, I joked at the beginning that having Ken on the speaking agenda makes what we have to say about passing laws downright conservative, which is not a position we're used to, which is usually we're the most radical voice in the room in many ways. So we're a little over schedule, so I'm going to try to keep this short, but we've been talking today about this concept of the community rights movement. So what is the community rights movement? I mean, in its biggest form, what is the movement? And the movement to me is about seizing legal authority for communities to be able to stop those things which are harmful to them from coming into the community. So unwanted, harmful projects coming in, that communities have the legal authority to say no to those projects coming through. So a pipeline coming through the community, people can take a vote and say, do we want this pipeline coming through the community, or a toxic waste incinerator, or a factory farm, or a sewage sludge land application? And as almost everybody in this room knows, that's not the system that we have today for the past 150 years. In the United States, the nasty little secret for most people who have not come into conflict with it is that if the state or federal government has permitted something, no matter how odious it is, that the community is banned from prohibiting that project, right? The black letter law. You can ask the environmental lawyers, you can ask the corporate lawyers. It's not a secret. It's not a Pandora's box that I'm opening today. This is well known to certain levels of government and people that work there. The folks that it's not well known to are us, until it smacks us in the face. So we live next door to something coming in, or it comes into our community, and it's there that that rule becomes relevant. And so we have a systems problem. We have a structural problem. And what you hear, and what I've heard for the past 21 years in my capacity in this position, is stories from communities, from people who are coming to grips with that fact. It's almost a grieving process, because we're taught since kindergarten that we live in a democracy, that this is the best and greatest system that's ever been derived on the planet, that the founding fathers are the best and intelligent white men that ever walked the planet as well. And in fact, you ask most people, they say the United States is the only country that has a constitution, right? So most people don't even understand the system in which we live, which is when you have a structural problem, the only way to defeat that, the only way to change it is to change the system, to change the structure. And a lot of what we do, we phrase as collective civil disobedience. It's people coming together in communities who are rejecting that system of law. But we all start at the same place, which is we can't believe that the system of law is there to start with, because we don't run into the corporations first. We actually run into our own system of law first. It's not the corporations, it's the state telling us we can't do X, or the federal government stuff in place, or the FERC saying X. And my mentor, Richard Grossman, used to open up these talks with a parable. And I think I'm going to expend some of my precious time talking about that parable. And he said, well, there's a group of hikers in the woods, and they're walking through the woods, and they come to this river. And one of the hikers looks in the river, and there's a baby in a bassinet coming down the river, in the river. And the hiker takes off his backpack, and he runs into the river, and he grabs the baby, and he pulls the baby out to the shore, and he goes, oh my God, look, there was a baby in the river coming down the river. And the other hikers look in the river, and they say, oh, there's another baby in the river, and another baby. We gotta get the babies out of the river. And they all put their backpacks on the ground, they run into the river, and they're pulling the babies out, and pretty soon there's more babies coming down. They say, oh my God, there's more babies in the river, we gotta pull them out. And their buddy, he gets out of the river, and he climbs up on shore, and he puts his backpack back on. And people are saying, what are you doing? There's babies in the river. We got to pull them out. We got to jump in. We got to pull them out. And the hiker looked back at his friends, and he goes, I'm going to go upriver and stop whoever's putting the babies in. Right? I think the community rights movement is about hiking upstream, right? It's about stopping what we've been doing for 40 years, which has essentially been doing that day-to-day defensive stuff about trying to protect ourselves hand to hand by pulling the babies out of the river. And we got to pull some of the babies out of the river. We still got to do that work, but we also got to go upstream. We got to figure out why they're being put in the river in the first place and how to stop that system or that structure. So we didn't start 20 years ago by giving talks about babies in the river. We started as a conventional environmental law firm because we thought communities already had rights, right? We started a law firm to actually enforce the rights, but we assumed that communities already had rights because that's what you're taught in law school. You know, that we have the best environmental law system in the world, that we export people out to other countries to actually replicate that environmental law system in other places. And we thought the problem was there weren't enough lawyers. That there weren't enough lawyers. That's how crazy we were. And so we created a law firm to add some more lawyers to represent these communities that were being hit with toxic waste incinerators and all these other projects. And so for about 10 years, we did what environmental lawyers do. We sat in a room and we compared corporate permit applications to the environmental regulations that are in place that control the issuance of those permits. So basically checklists that the state agencies would go through, and then they would issue a permit. We would come in, we argue you shouldn't have issued the permit because you missed a signature, or a bond amount was wrong, or a macroinvertebrate study wasn't prepared correctly, all those different things to the judges, and we would win most of those cases, and then the corporation would just come back the next week or the next month, and they would say, thank you very much. I had some of the largest law firms in the United States thanking me for finding gaps, omissions, and deficiencies in the corporate permit applications, because then they could bill the corporation more hours to actually fill in those gaps, deficiencies, and omissions to then bring back the permit application again. So that's basically where we ended up. We had one case, I have to share it with my limited time again, but we had one case with a wood chip operation where somebody was trying to stop a wood chip mill in their community. And it turned out the wood chip corporation didn't have a permit to operate. And we thought, aha, we gotcha, because you don't even have a permit. You never even applied for a permit. And then the next day, the DEP retroactively permitted them by fax. By fax, right? I mean, the worst part is retroactive, but the fax is kind of fun too, right? So the agency sends a fax with the permit to retroactively permit them for the time period that they were operating without a permit. How crazy is that, right? So a lot of people come up to us and they say, well, the regulatory system is broken. It's not protecting our health, safety, and welfare. It's not working. It's broken. To which we now say, maybe it's not broken. Maybe it's working perfectly, right? Because maybe its purpose isn't to protect health, safety, and welfare. Maybe its purpose is to have an insulating level, a layer, between the people in the community and the corporation itself that we have to tangle with, so that the corporation doesn't have to, that they have an intermediary in the state and these Department of Environmental Protection and the other state agencies. It's not called permitting for nothing. It permits something that would otherwise be illegal, right? That's what the permitting process is. It's issuing those permits. It's legalizing a harm. And we don't usually think about it that way. We think about it as a protective layer. But they're not called permits for nothing because that's how they function. Yet, you know, these permit processes and regulatory stuff, which is where we all started, we go to these regulatory hearings, we talk to the state regulators, we give comments, we do the testimony. Unfortunately, it's all a democracy theme park, is what we call it in these two-day trainings that we do, because the microphones aren't even connected. Nobody's listening. Yet we spend our time in that hamster wheel of the regulatory stuff. Some other stuff about the regulatory stuff that we learned that eventually led us to quit doing the regulatory stuff, which is that just the word regulate, the verb, means to regulate an ongoing harm. It's not about stopping anything. It's actually about just shaving off some of the worst effects, right? So even the word itself doesn't recognize that our communities have any legitimate role in the process to actually stop a project that we've deemed to be harmful to us. Worse yet, the monies that the corporations spend, because at least we thought we were costing the corporations money by dragging them into these permit appeals and into these fora. The monies that the corporations spend are tax deductible, that they use to fight us. They're reasonable and necessary business expenses under the law. Yet, of course, the burden on our side is carried by us. If we do a permit appeal, we have to do the fundraisers and the cake and cookie sales and raise the nickels and dimes to pay for the photocopies and the lawyer to go into these processes. How fair is that? So structurally, we have to bear the financial burden. But on the other side, the corporations aren't bearing any financial burden because it's tax deductible. We came to the conclusion that the only thing that environmental regulations regulate are environmentalists, because they make us predictable as to how we fight, right? The environmental regulations are written by the very corporations that ostensibly they're supposed to regulate. I worked in the state capitol in Pennsylvania for a number of years. I watched as the agribusiness corporations, their lawyers meet in a room, they write the legislation, and they give it to the Senate and the House chairs of the ag committees. It's that straightforward. In fact, we had a reporter in North Carolina who became a friend of ours, and he said, you know, just on a lark one day, I asked the chief Senate guy where this legislation, jokingly, where this legislation was being written so that he could go and meet the people who were writing it. And the Senate guy said, yeah, it's room 124 in this in the Capitol. And so the reporter went, sure enough, there's the concept group that was coming up with new legislation for agribusiness corporations in the state of North Carolina. So that's just the way it works. And a lot of people who work in government just expect it to work that way. It's the status quo. But again, when we run up against it in our communities, it's this entirely new, shocking things to us. So the question we get the most when we're out speaking or in the office, when a new community comes in the doors, why can't we just say no to these things? Why can't our community, our town, our village, our city, our county, why can't we just pass a one-paragraph ordinance that says no pipeline, right? It should be that simple. Why can't we just pass a one-paragraph ordinance that says no pipeline? Well, there are 3 reasons. And those 3 reasons are tied to legal doctrines that have been carefully concocted over the past 150 years to keep you in a box so that you can't say no to these things coming in. We've talked about some of them today, but one of them is preemption. We're all pretty familiar with preemption. The state and federal government, whatever they pass, is supreme over you. So most states have oil and gas acts, and those state oil and gas acts preempt your municipal community from passing anything that regulates oil and gas operations more stringently than the state, right? And in law school, people just pretty much accept that. But how anti-democratic is preemption? It pulls the power further away from the community into a smaller number of hands, away from those people who are affected by that particular issue. Corporations have made a field day, a marketplace out of preemption stuff. When you look at Pennsylvania, we've looked at Ohio, New Hampshire, Colorado, Oregon. When you look at the preemption stuff, it's a scheme. Whenever opposition arises substantially in a specific area, the response is for the corporations to go to the state and pass a preemption law. That's what they do. They're using the state. You know, we talk about the corporate state. They're using the state to pass those preemption laws because it's more efficient for the corporation to get a state law passed that's uniform across the state than to chase each community, right, through their lawyers and suing them and all that kind of stuff. It's more efficient. It's nothing personal, right? It's just business. And that's how the coordination works between the state and the corporation. So in addition to preemption, what's the second doctrine? Well, it's something called Dillon's Rule. Dillon's Rule comes out of the 1900s. Early Iowa Supreme Court justice who came up with this rule called Dillon's Rule. What is it? Doesn't matter what the name of it is. It's all about municipal subordinacy to the state. So whereas preemption is the state says you can't, the default in the United States is that your municipality can't pass any law unless it's been specifically authorized to pass that law by the state. It's like the flip side of preemption. So you have preemption and you have Dillon's Rule. Dillon's Rule is like the ultimate, you don't have power by default unless the state chooses to give you that power. And if you think the state is ever going to choose to give you power to block a pipeline or a frack well or oil and gas extraction, you're crazy. And we shouldn't be waiting for it, because that's not going to happen. So what's the third doctrine that keeps you in this box? Well, it's something called corporate rights. We've touched on it a couple times today. Corporations have constitutional rights under the law today, right? We probably all heard about Citizens United, where corporations were recognized as having free speech rights. Free speech rights to the extent to knock down campaign finance laws in the United States. There was a little decision called Hobby Lobby, if anybody caught that one, where, guess what, corporations can have religious beliefs and knock down federal provisions and federal law on that basis. Corporations for the past 200 years have slowly accreted different constitutional rights in the United States. So that Walmart Corporation has the same constitutional rights as you or me. They have free speech rights, they have Fourth Amendment rights, warrantless search and seizures. They have a full spectrum of constitutional rights that you and I have as natural people, but corporations have claimed those as well. Why does that matter in this context? Why does it matter that corporations have constitutional rights in this context? Well, it matters because of this. When a corporation has a permit, is issued a permit by the state or federal government, that permit, that piece of paper, is considered property, right? So we have to get our brains around that. It can be bought, it can be sold, permits can be transferred, they have value, monetary value, they're property. Under the Constitution's Fifth Amendment, you can't take property without just compensation, right? So under the law, because corporations are persons, they have Fifth Amendment rights, and you can't take their property without just compensation. That's why when the corporations sue our municipalities, they don't just ask for overturning the law that you've passed. They ask for damages. And the damages that they demand from your municipality are in the amount equal to the future lost profits lost as a result of the law that you've passed, right? And that's the constitutional theory that is integrated into the corporations when they sue our municipalities over these rules. So it's all very complex, but all to say that communities are beginning to untangle that complexity and begin to ask very dangerous questions, dangerous to the corporations and dangerous to that structure of law. And the first question that they ask when we tell them that corporations have constitutional rights and they could get sued for violating those constitutional rights is, why? Why do corporations have constitutional rights? To which we say, we're so happy you asked that question, we know the answer to it. And the answer is that the Supreme Court and other courts in the United States have recognized corporations as persons under the law beginning in the 1820s. And all the way up to today. It's continuing to change. The corporations have these rights. And the communities then come back to us and say, why? Why are corporations persons? That doesn't make much sense. To which we've started to engage them in a conversation about how the U.S. Constitution itself, the DNA of this country, is about the elevation of certain rights over others. The rights of property and commerce over the rights of people, communities, and nature. That's basically imprinted into the constitutional structure. So it's not an accident that corporations became persons for purposes of the constitutional structure. People tend to think, oh my God, that's just an accident, and the Supreme Court justices are all going to slap themselves on the forehead and say, oh my God, we were wrong for the past 200 years, and let's change this. Right? But it wasn't an accident at all. If you're going to have a fundamental DNA in the country, the constitutional DNA, that recognizes property and commerce as the highest values, it makes perfect sense to protect those values by protecting the actors that are active in property and commerce within that system. So it's actually very logical that corporations obtain certain rights, and the problem is not just corporate rights, it's actually the DNA of how our system is written. So when we talk about structural change, we're actually talking about the whole enchilada. We're not talking about just the surface stuff, we're talking about something that goes back even to this level of DNA. So what happens when our communities pass laws? Well, they get sued. It's almost a guarantee, right? Because the laws themselves are opposite to the existing system. They're like the matter meeting antimatter, right? And what happens next is that the corporation sues the community. When the corporation sues, those three legal doctrines that we talk about are all privately enforceable, right? It's not like the state comes in and sues you. Well, not most places. It's not like the state comes in to sue you and says, hey, you know, the state of Ohio says we have an oil and gas act. You're violating our oil and gas act, and we're suing you. So it's the state of Ohio versus Medina County. It doesn't happen. What happens is the corporation takes the laws that are in place and privately enforces them against the community. One way to look at it is like a boxing glove. You know, the state creates these rights, these constitutional rights on behalf of corporations and preemption and these other laws that shelter them. And then the board of directors of the corporations or the corporate decision makers put on that structure of law like a boxing glove, and then they beat the shit out of your community, right? That's the history of the past 40 years. But they can't do it without your state, right? It's not a corporate problem that we have. It's a government problem. It's a state problem, right? And it's this coordination between the corporation and the state, which has caused the problems that we find. So as those lawsuits come in the door, once again, they don't ask just for the ordinance or the law to be overturned. What they demand is damages for violating the corporation's constitutional rights. And that can be millions of dollars, because if you're locking up the gas reserves underneath the community, the lawsuit that comes in the door is for the value of those gas resources that can't be accessed as a result of the ordinance that's been passed to ban oil and gas extraction within the community. So it's one thing to be an elected official and say, hey, nothing ventured, nothing gained. If we pass this ordinance, lawsuit comes in the door, it'll just get overturned. It's a whole nother thing when you see a damage claim come in the door. But that's one of the levers that they have to use as a result of these corporate constitutional rights. Now, we're not naive enough to think that the judges and the courts are going to respond within the next 5 years and say, of course you have a right of local community self-government, you people of Ohio. We're bestowing that on you now, even though it pisses off every corporation that does business in the state of Ohio and the entire political structure, which has benefits flowing to them from that structure. So, because of that, we feel the need to go over the judges and over your elected officials to actually begin to do constitutional change textually. So what do I mean by that? Well, it means these community rights networks that have formed in various states from the communities stitching themselves together who are doing this work at the grassroots level to begin to drive state constitutional change. There are some things you can change structurally by changing your state constitution. One is to drive in a new right within your Bill of Rights that recognizes a constitutional right of local community self-government, to legalize what you're already doing, right? To use state power to legalize what you're already doing. That right of local community self-government then makes these other doctrines unconstitutional. So corporate rights violate your right of local community self-government. Preemption, when it's exercised a certain way, violates your right of local community self-government. And Dillon's rule, of course, by itself violates that right of local community self-government. So folks are moving in a variety of places to push upwards from the grassroots community level to begin this constitutional change. We think that in the end, federal constitutional change is necessary, because when you trace the DNA back, you gotta tear out the cancer at the lowest levels. Otherwise, you're left with fighting against that over and over again. And just to finish out today, I wanted to talk a little bit about what movements do. So we've talked about a community rights movement. And the community rights movement models itself after other movements. What makes for a successful movement? What is a movement, a people's movement in the United States? Well, to be a movement means to take stuff that's treated as a thing under the Constitution and transform that thing into being a rights-bearing entity or a rights-bearing person. So from a thing to a person. So if you think about it, the abolitionists, when they were working to free the slaves, transformed property that was a slave under the law, which had no rights, was not treated as a person, and transformed that piece of property, that slave, into being a rights-bearing person. Suffragists did the same thing. Women were property. Rape was not a crime in the 1840s because a woman was not a person. You paid damages to the brother or to the husband. So a woman was a piece of property. That the suffragists transformed, for some purposes, women from being property into being persons, right? That's what movements do. They take things that are treated as things under the Constitution and they transform them into rights-bearing entities. I would suggest to you today that your communities are property. Your city, your village, your town, your county, they are property under the law, which can be used however the state or the corporation wants to use that property. What we're talking about is a movement that transforms that which is property, a municipal corporation that you're pigeonholed in now as a city, town, village, county, whatever your municipality is, and transforming that into a democratic, self-governing entity. That's the movement. Right? So one other small thing to talk about, which I didn't talk about last night, but I wanted to add tonight, which is that when we talk about community, we're not just talking about the people that live in the community. We're talking about the ecosystems and nature in a community. I was joking the other day, we all use this language, it's like talking about a vacant lot in a community. We say, oh, well, that lot is undeveloped. Well, no, even if we haven't built a house there, it's still pretty developed. It's got ecosystems, it's got oxygen transfer mechanisms. It's very complicated, actually. It's not undeveloped. But even our language talks this way about nature and ecosystems. Like nothing exists on that land unless we actually improve it. In fact, we talk about improvements in the real estate field as well. Part of what these communities are doing is redefining what community means. At its base, the community rights movement is about community self-determination. But it's also about redefining the word community. It's not just people, it's ecosystems and nature and everything that we rely on for life support systems. And so the shift that we're helping communities to make is to transform nature and ecosystems from being property into being rights-bearing entities. And so that concept of the rights of nature as being part of that community self-determination drive has become part of ordinances and charters and laws in the United States, which we think is on the cutting edge of a new field of environmental law, which is nature's rights. And we were the folks that went to Ecuador and assisted the country of Ecuador to write a new constitution that had rights of nature in it. We've assisted with the enforcement cases there. Some people may have read last week, some courts in India recognized a river as a person. That's out of the blue, although we've been working with groups in India and Sweden and other places to make that kind of stuff happen. So I think that's very exciting as well. And finally, just the last thought here is that we need to rediscover this spirit of civil disobedience. We get folks all the time who say, oh my God, you know, we'd love to do the rights-based work, but if it means getting sued, we're out of that. We just can't do that, right? Or you know, there's other sacrifices that come with that we just can't make, but the lawsuit's the biggest thing. We just can't get sued, so we're not going to do it in the first place. Movements in the past would have loved that the worst case scenario for them was to get sued, right? They would have prayed for it, right? The Freedom Riders in the South, Rosa Parks on the bus, the American Revolution. This country was born in civil disobedience. It was born at Lexington and Concord, where people picked up guns and got shot on the Lexington Green for slowing down the British soldiers as they came through to pick up the arms from the revolutionaries. We have to understand that this country, change only happens through conflict and struggle. It only happens through sacrifice. The other side is betting that we don't have what it takes to make this kind of change. I've been one of the rare people on the phone calls of the corporate council and the round table, the lawyers for the corporations. They're constantly organized. They're having calls every week because they say, hey, this happened in Ohio, how do we head it off in Pennsylvania, right? How do we write this law in Pennsylvania to stop it from happening as it happened in Ohio? They're always thinking, they're always strategizing, and they're laughing at you for the most part for the past 40 years. They're not laughing anymore. Right? When they have the need to come after a Grant Township using state power to do it, they're not laughing anymore. They're taking it seriously. That's what the community rights movement is about, and we need to rediscover that spirit of civil disobedience to make this change because nobody else is going to make it. Thank you.